Have you ever wondered about the evolution of South Africa's judicial system, particularly the Supreme Court of Appeal? The court's roots can be traced back to the Appellate Division, a court that unified the various divisions of the old Supreme Court of South Africa. Known informally as the AD, this court was the chief legal authority in the land. With the advent of the Constitution, the Appellate Division transformed into the Supreme Court of Appeal, or the SCA. Located in Bloemfontein, it oversaw the entirety of South Africa, handling appeal matters exclusively. The Supreme Court of Appeal was the pinnacle of appeal courts in the country, barring constitutional matters, which fell under the exclusive jurisdiction of the Constitutional Court. The Supreme Court of Appeal, with its president, deputy president, and a host of judges of appeal, played a crucial role in shaping the legal landscape of South Africa. From its inception, the Supreme Court of Appeal held a significant role in the South African judicial system. But what happens when a system evolves? Let us delve into the transformation of the Appellate Division into the Supreme Court of Appeal. Historically, the Appellate Division was the principal court in South Africa, uniting the various divisions of the old Supreme Court. Known as the AD, it held a significant position in the judicial landscape. However, as per Schedule 6 of the Constitution, the Appellate Division underwent a metamorphosis, transitioning into what we now know as the Supreme Court of Appeal, or the SCA. This new entity emerged as the highest court of appeal in the country, a position of great prominence. But there was a caveat: it did not hold jurisdiction over constitutional matters. This exclusive domain was reserved for the Constitutional Court, a specialist court dedicated solely to constitutional matters. In essence, the Supreme Court of Appeal marked a new era in the South African judicial system, taking on a role that had been previously held by the Appellate Division. The Supreme Court of Appeal began to carve out its unique identity in the South African judicial landscape. What happens when the rules of the game change? In 2012, the South African judicial system experienced a significant shift. This shift was brought about by the Constitution's 17th Amendment Act of 2012, which stirred the waters of the court hierarchy, reshaping the roles and responsibilities of the country's topmost courts. Historically, the Supreme Court of Appeal, or the SCA, as it's often referred to, held the position of the highest court of appeal in South Africa for all matters, except those of a constitutional nature. Constitutional matters lay within the exclusive jurisdiction of the Constitutional Court, a specialist court specifically designed to handle issues relating to the Constitution. But, as the old saying goes, change is the only constant. The Constitution's 17th Amendment Act of 2012 marked a significant turning point in the South African judicial landscape. This crucial piece of legislation elevated the Constitutional Court to the highest court for all matters, constitutional and non-constitutional. Suddenly, the Supreme Court of Appeal found itself in a different position within the court hierarchy. The SCA was reduced to an intermediate appeal court, a move that could have been seen as a demotion. However, it's important to remember that change doesn't always signify a loss. Indeed, while the SCA's position in the hierarchy shifted, its jurisdiction, the range of cases it could consider, was broadened. Under the new legislation, the Supreme Court of Appeal can now decide appeals in any matter arising from the High Court or any court of a status similar to the High Court, with the exception of certain labor or competition matters. This expansion of its jurisdiction means the SCA has a wider scope to influence legal decisions and outcomes in South Africa. With these changes, the Supreme Court of Appeal adapted to its new role, continuing its vital function in the South African judicial system. Despite the hierarchy shifts and constitutional changes, the SCA remains a key player in the country's legal landscape, ensuring justice is served and the rule of law upheld. This brings us to the present day. So, where does the Supreme Court of Appeal stand now? Today, the Supreme Court of Appeal, or SCA, retains a significant role within the South African judicial system. Seated in Bloemfontein, the SCA has a national jurisdiction, but only in matters of appeal. Its structure comprises a president, a deputy president, and numerous judges of appeal, all working together to uphold justice. Despite the constitutional 17th Amendment Act of 2012, which shifted the hierarchy of the court system, the SCA continues to be a vital cog in the judicial wheel. The SCA now acts as an intermediate appeal court, deciding appeals from the High Court or courts of similar status, with the exception of certain labour or competition matters. This court's journey, from the Appellate Division to the Supreme Court of Appeal, is a testament to the adaptability and resilience of South Africa's judiciary. As we've seen, the Supreme Court of Appeal's journey reflects the dynamic and evolving nature of South Africa's judicial system.